What would you say is the most common mistake people make when negotiating or pushing for equal parenting time?
I think
Welcome, everyone, to Illinois Family Law Insider Podcast. My name is Katie VanDeusen. I'm one of the managing partners at Sterling Lawyers. And with me today is Senior Associate Leah Diaz. Thanks for joining me today, Leah.
Of course.
So today we're going to be talking about when equal placement works. There are clearly different factors like how equal placement can impact you legally, financially, and what are the practical realities of having equal shared placement? And when is it possible in Illinois? When does it actually make sense? So we're going to answer all of those questions together today. And let's start off, Leah, with what does 50-50 really mean in legal terms when it comes to children in Illinois?
Yeah, so 50-50, what we're really kind of leaning into is with respect to parenting time. 50-50 also can apply to the other aspect of things, which is decision-making responsibility. But really, when we're looking at 50-50, we're looking at parenting time. So that generally refers to an equal, or just given the calendar year, a near equal amount of overnights with your children or child, which shakes out to be anywhere from 182 to 183 overnights within the calendar year.
I feel like most of the time when we're talking about decision-making responsibilities, we as attorneys and parents should really think of it as joint or sole decision-making or custody. I use air quotes, custody is what we used to say. And then you're right, parenting time is really what I think comes to mind when someone says 50-50. And then the other question I think a lot of parents may have, Leah, is, is 50-50 parenting time in Illinois the default? Is that where the judge's mind automatically goes or where the statute automatically goes?
Yeah, so it's really not a default. It makes it vague for parents when they're really just looking for a straight answer of like, is 50-50 something I can expect? Really what the court's looking at is what's in the best interest of the child or children. So 50-50 is not going to be like a default setting for judges. It's really going to be what works best. So they're going to consider things like history, how, who's really kind of taken on that role of primary parent, if there's been a primary parent role or if both parents have been involved, how the parents can work together. Do we think they can co-parent together? And just like random logistical things like distance between the parties, work schedules, things like that.
Got it. Do you know, just based on your experience, Leah, are there any other factors that the court would look at, or are there any, main takeaways for people who are listening or watching today that you might be able to flag for them?
I mean, overall, the court's looking at best interest of the kids. That's really kind of the umbrella of what they're looking for. But I mean, clear logistical issues are always going to be things that the court's going to look at to be like, is this something that the parties can even do? So distance and work schedules are things to really be cognizant of is what I'm looking for something that's practical? But then I think you're also kind of looking for like, how is my child or children going to be able to adjust to these types of things? Like when it comes to school, their home, their community, and again, kind of the history involvement. But really, I think another big thing that courts look at is the ability of parties to communicate and cooperate if they're going to have a 50-50 schedule, because they're going to be overly involved with each other if they're going to be sharing that much time with their kids. Another thing that courts may consider is, child's needs or preferences, but that really depends on age and the maturity of a child if they're going to consider something like that.
Yep. One factor of many is what I usually tell people.
Yeah.
And then, Leah, I think this is kind of where people might naturally go next is, if you do have equal parenting time, does that mean automatically that no one is paying the other parent's support or child support of any kind?
Not necessarily. So what the court looks at is what's called an income share model. So even with equal parenting time, if one parent makes significantly more, of course, they're probably still going to be paying child support. But even if there is a discrepancy in income at all, there's still a situation where the person who makes more can be paying child support.
Yep, absolutely. And, can you give maybe a summary to people who are listening or watching as to how that formula would work in circumstances where both parents are exercising equal parenting time?
Yeah. So then what we're really looking at is the party's income primarily. So that's getting calculated in first and foremost. And then the support amount is going to be shared in proportionality to those parties' incomes. There's like things that can kick in if each parent has at least 146 overnights, which is about 40% of the time in the calendar year, which basically what that means is if you are exercising 40% of the time in the calendar year, your child support obligation is going to be low. In some cases, the other parent could be paying child support depending on income, but we're really sliding that scale the closer we get to 50-50 to where it simply just comes down to income at that point.
Yeah. And I feel like a lot of times people will ask, like, well, what is this, specifics when it comes to support? And it's like the formula is not one where you could just easily jot it down on a napkin. It's like you really do need to run different support scenarios based on how many overnights there are. And there's not just like I could do that off the top of my head. I think the way that you're describing it, though, makes total sense, where if you have at least 146 overnights or more, it's almost like a sliding scale. And it doesn't mean that it's going to be a small support obligation. It really is driven by the income levels of the parents. And it just means that the more overnights or the more parenting time for overnights that you exercise, maybe you would see a slight reduction, and that sliding scale increases as you get closer to that 50-50 kind of amount, that 182, 183, as we like to call it.
Correct.
And then, Leah, in terms of child support, with equal parenting time, can courts deviate from that amount? So even if you do have if you're applying the statutory formula, what does that look like? Do courts just automatically apply that and that's what they go with? Or how does that work exactly?
I mean, when it comes to like what could be a default in these types of situations, the guidelines is going to be your default. That's your kind of starting off point. And then in circumstances, depending on what parties are asking for or presenting to the court has the ability to deviate from that support guideline. Obviously, if parties agree to it, that's kind of the most sure way that a deviation is going to be accepted by the judge, or there are specific facts that the court hears that would support the deviation. So, for example, I've had some circumstances where one parent is willing to take on more of like child-related expenses, like out-of-pocket costs. And as a result, then the court agreed to deviate where that person wasn't going to pay child support, or it would be set at zero because they are taking on more of those child-related expenses. But, other costs like daycare, health insurance, extracurriculars, who's taking on all those expenses, things like that. Those are things that the court can consider.
Definitely. And then in terms of, how this logistically applies, or practically speaking, if people are referencing an equal parenting time schedule, based on your experience, what does that actually look like in real world practice?
Most common examples I see are alternating weeks and then what's called a 2-2-3 schedule. There's also like other shared schedules that exist, like 5-2-2-5. I mean, you can like Google to the end of the earth, these different shared schedules that can exist. And in truth, if you want to do a 50-50 schedule with the other parent, you can get creative. You can figure out ways to make it work. Whether that's one person has more time in the summers or breaks or things like that, you can certainly make those things work and it can be tailored. But alternating weeks and the 2-2-3 are the most common. 2-2-3 primarily where one parent has 2 set days during the week, like a Monday or Tuesday. The other parent has Wednesday, Thursday, for example, and then they alternate those weekends.
Got it. And then what would you say are the keys to consider when thinking through what schedule is best for your family or your children?
Yeah, I think, again, it's really just tailored to each party's circumstances. So like you want the most consistent and predictable schedules for your kids. And that's what the court's going to be looking at. The age of the children. So like what's something that we think based on their age they can tolerate, that's sometimes what lends more to like an alternating week schedule where they're not going back and forth as much. The party's ability to coordinate, communicate, and do those back and forth. Those are a lot of things that they'll look at.
Definitely. I feel like it's, not a one size fits all. And it really is just so unique to the family and the parties, and also maybe recommendations you're getting from a guardian or a judge directly. So it's not a one size fits all by any means. And Leah, what would you say are the biggest challenges that you've personally seen in practice when it comes to equal parenting time schedules?
I think the biggest challenge is to overcome, whether it's a judge thinking it's a good idea, a guardian ad litem thinking it's a good idea, or even the parents thinking a good idea, is the amount of transitions depending on the kid's age. Kind of like what I said before, younger kids and doing a lot of bouncing back and forth is going to be something that's going to raise a little bit of eyebrows. So that's usually why that week on, week off is usually more considered with younger kids. But again, whatever each person can make work and what the kids can feel comfortable with and do. Inconsistent work schedules for sure. I know that you and I can have both dealt with this in cases, but
Yeah.
again, I really think when it comes to 50-50, that comes down to parent communication and their ability to co-parent. If there's work schedules that are really inconsistent, or like it changes on a monthly basis, or travel, things like that, and then communication breakdowns between the parents also, again, create the biggest challenges, because with 50-50 schedules, you're really going to be dealing a lot with that other parent.
I could not agree more. And I do feel like it's so hard to, I don't know, overcome some of those challenges because, the ones that I've seen consistently are okay, if you do a week on, week off, that's a long time where a young child may not be having contact with the other parent. But then again, it creates that stability and that consistency where they feel like they've actually spent time at the other person's household and been able to kind of like acclimate to their home. And then you see these other schedules like a 2-2-3 where that's great, but then the child may end up feeling bounced or may not feel like they can really call a place home for more than 3 consistent days. So it's hard to kind of navigate those situations, and they're so fact specific, and also like based on, like you said, the child is individual, or the children as individuals, and what is in their best interest.
What they can do, yeah. And then with that 2-2-3, I think the most important, obviously this is applied during like school breaks and things, but with that 2-2-3, to kind of prevent that bounce back and forth, what we're really trying to do is make those transitions take place around school time. So whether it's drop off at school, pick up at school, that's when those transitions would take place. So it kind of, they're in the same spot. It's just who's picking them up. So that kind of alleviates some of that back and forth, but that's always going to be a concern.
Totally. And then what advice would you give to parents who are considering equal parenting time, but maybe they might not be sure how to make that work on a day-to-day basis? Do you have any tips or tricks for those particular listeners or viewers?
I would say know who the other parent is. If you think that communication is something that you guys can be successful on, it's really hard in situations where one parent really wants to co-parent and kind of put the issues aside, and then the other parent doesn't want to. So even though you want to and you can the other parent do that? So if the answer is no, maybe 50-50 might not be something that can work. Or maybe we have to look at a specific 50-50 schedule where the communication isn't going to be as burdensome. But I think be really realistic about the other person that you're dealing with in the situation. I also think if you can, try trial runs on things if you guys are in agreement. So if you think that you can make something work before you agree to finalize that, give it a whirl. Maybe either on a temporary basis through a court order, or you guys do it on your own. But once that becomes a final order, like we've talked about previously, it becomes more difficult to change unless it's by agreement. So really feel that out first before you're like, this is a good idea and I think we can do this.
Definitely. And then have you ever had a case, Leah, where equal parenting time may have looked really good on paper, both parties were on board with it, but it really was not practical in that particular situation?
Yeah, I think the case that really stands out is where co-parenting was great. They, if there was issues to overcome, they could do it with the communication. But when it came to the practicality of doing it, given one of the parents had a fairly unpredictable work schedule, and then it required a little bit of like a further relocation based on the work, it really wasn't panning out well for the kids and the parents, just because it was a lot of work to make that 50-50 work. So it really wasn't practical for them.
Yeah. I had a case once where the work schedule required one parent to travel like a substantial amount of time. And just like you alluded to, it's like they could have had the best co-parenting relationship, but if one parent, they weren't physically present or able to do that kind of put a wrench in things for sure.
Yeah. I think too, judges, like when it comes to predictability and like consistency in that, if you're going to say that you can do this time and you guys can be flexible on that, but if a kid's expecting to have time or that predictability with their parent and then it can't happen, that's when you see issues start to happen.
Absolutely. And then what examples, do you have in terms of your experience where maybe parents made an equal parenting time schedule work really well because they focused on the child's needs and kind of setting aside their own maybe personal issues towards each other, and they made it work?
I mean, that's the biggest thing, is they can set their own issues aside and focus on their kids. I think that's really when you see 50-50 work beautifully, is when they can kind of move on from why they got divorced and they know that they want the best for their kids. But I really think it comes down to their ability to co-parent, because everything else for 50-50 kind of falls into place when it comes to like practicality of it all. Do you guys live close enough? Work schedules, like can you make it work? But I think when I really see it work really, really well is they can have a really good co-parenting relationship and the communication is there, because things come up, you enter into this allocation judgment. And when you have a good co-parenting relationship, you look at that agreement as your default. Like if you ever need to fall back on that, that's your default. But you guys work together because things come up in life. If you have an unexpected trip or something's going on, maybe the kid wants to spend a little bit more time with mom because the kid misses her. Dad's like, go for it, whatever. Those things are just what happen in life. And if you guys communicate well, you move forward.
Definitely. And the kids win ultimately too with that type of an outcome. And then have you seen, Leah, a case where, maybe equal parenting time or even like, let's just say 150 overnights based on what we've previously talked about. Have you ever seen that either reduce and or eliminate the child support obligation? And how did that practically work in that case?
Yeah, I see it in a couple examples. I think obviously, of course, if income's close enough and like obviously if guideline makes it happen, then that's what we're working with. I have people like where like child support would be like $100 a month or something like that, and they're like, this is like, don't worry about it. We'll just figure this out. But I've also seen in situations where, there would be a child support obligation owed, but no one's really looking for that. They can reserve the issue of child support, meaning that it's not set. Either party then would have the opportunity to come back and set support, but it just kind of makes it a non-issue when we're entering everything. I've honestly seen judges like reservations of child support because then they kind of know what these parties are agreeing to. Child support's not the driving factor of what they're looking to accomplish. And instead it's for the kids. So
Yeah, it's so interesting. And you made a comment earlier, like either child support being set at 0 or a reservation. I do think some judges have like particular preferences for either one of those. So just be aware of, your judge and who you're in front of as to whether or not you might want to lean towards a reservation versus setting the support obligation at 0, which would then trigger, modification issues in the future. So
correct. Mm-hmm.
in order to kind of wrap up, you have shared so much amazing information with us all today, Leah. But if I were to ask you, what should a parent ask themselves before pushing for equal parenting time?
Oh my gosh, so much. But I think first ask yourself, are you doing this for your kids or are you doing this for you? If it's something that's practical, you think it's best if both parents are involved, 50-50 is what's best for your kids. It's practical. You guys can do it. Sure. If your driving force is child support, you're going to be spending a ton of money litigating this anyway. I really rethink that. Like you're not going to be taking on a lot of those day-to-day costs if you don't have 50-50 time like the other parent would. So really child support's not something that's worth fighting over a 50-50 for if that is your driving force, child support. So I think really get behind the reasons that you want 50-50 and then figure out, is this best for my kid or kids, or is this what I think would be best for me?
Definitely. What a good takeaway. And then one other key point while we're, close to wrapping up, what would you say is the most common mistake people make when negotiating or pushing for equal parenting time?
I think a big issue I see, or mistake, I guess I see, is what I've noticed as a trend is people unilaterally refusing time while they're negotiating or kind of like taking away that other parent's parenting time on their own. I've seen different strategies on how to do that since kind of like, people think like mom gets the parenting time. That's really not the reality anymore. So I think there's been like different ways people have tried to get a one up on the other parent. And really that's not the best way to go about that. I know other attorneys may disagree with me on that because they're, kind of setting a status quo for themselves, and thinking that's what's best. I really don't think that's what's best. I do not think that's the best route to take. Because if you're unilaterally taking away that parenting time from the other parent and a judge gets involved or a guardian ad litem gets involved, it doesn't look good that that's what you're doing.
Agreed. And then what is your main takeaway or best advice when it comes to making equal parenting time work in a high conflict or maybe highly litigious case?
I think make sure the practicals pan out the best for you. Like you guys are living close together, your work schedules allow for it, your kids want that. I think really making the rest of those factors, probably all of them, be in your favor, especially if your guys have such a high conflict relationship or co-parenting relationship. I would make sure everything else pans out and that you both are really involved parents and can make that logistically work.
Absolutely. Well, thanks so much, Leah, for joining me today on Illinois Family Law Insider Podcast. And I appreciate you just sharing all this information and these tips with everybody today. It was very, very insightful.
Thank you.
And while parenting time gets most of the attention, it's often what happens behind the scenes, like custody evaluations, that end up shaping the outcome. What triggers them, who conducts them, and what rights do parents actually have in the process. Click to watch the next video because most people don't find out until they're already in one.